So, ladies and gentlemen, my name is Alexander Zajnowicz from the University of Mainz, and today I will present some thoughts about convergence or persistence in corporate law theory, what to expect in the ESG era. So what's our agenda today? I am examining essential differences between German and US corporation law, which I am pointing out on the basis of the differing paradigms of the corporation in the two legal systems, which can be characterized by the dichotomy of collectivism in Germany and individualism in the US. I will exemplify these differences with the classical debate about the interest of the enterprise concept versus the shareholder primacy concept. And I will also examine conceivable lines of convergence in light of the some current developments. So what do I mean by the two paradigms? So we have in Germany the so-called real entity theory, or the entity theory concept, that has heavily influenced German corporate law development since the 19th century, and is still today the prevailing the prevailing theoretical foundation for corporate law in Germany. And what follows from this is that we have a sharp distinction of the articles of association from a contract in Germany. So the formation of the corporation is described as a creative act of organization. The statutes are equalized with quasi-legal norms, and what follows from this is the so-called principle of the strictness of the statutes, which means that deviations from the statutory form are not permitted. In addition, the corporation and its purpose are independent from the purpose of its shareholders. There is the supra-individual purpose of the collective, the corporation as such. We have fiduciary duties on the part of the management owed not vis-à-vis the shareholders directly, rather solely to the corporation. And another point is that shareholders in their capacity as members are obligated to act in the corporation's interest. So we have a vertical fiduciary duty of all shareholders vis-à-vis the corporation. In the US, to the contrary, we have the nexus of contract theory, or what Susan Watson just called the property concept. So this is, but in the form of the nexus of contract theory, I think it's originated in the law and economics movement of the 1970s and the modern theories of the firm, which themselves originated in economic theory. So that the idea is that corporate law should define conditions that would be negotiated by rational actors at arm's length in a hypothetical bargaining scenario if transaction costs were sufficiently low. And Delaware stock corporation law comes at least close to this idol. I have a quote by Leo Strine who said that Delaware corporation law governs only the internal affairs of the corporation. In that sense, our law is a specialized form of contract law that governs the relationship between corporate managers, the directors and officers, the corporation, and the stockholders. So there is a focus on this in this relationship. And what follows is, first of all, the articles of association are a contract from which extensive dispositivity follows. We have a purpose of the corporation itself that is distinct from the interest of the shareholders as a class is hardly conceivable. We have a line of fiduciary duties owed by the management also directly to the shareholders, and shareholders can pursue their individual goals and are not tied to any overriding or supra-individual purpose of the corporation. So why is this? So in Germany, at least, there is a collectivist or holistic basis for this real entity theory. The theory as such is an expression of a collectivist mindset that is characteristic of the development of German corporate law, originating in German Romanticism and the German historical school of jurisprudence. It culminated in the 1920s in the theory of the enterprise as such, but it's still relevant today for the theory of the interest of the enterprise, which I will talk in a few minutes. And we have a clear lack of influence of economics theory on jurisprudence and legal development in Germany. On the other side, the US, normatively and methodologically individualistic basis. The starting point is the individual, which is also expressed in the methodological individualism underlying the contractualist theories of the corporation. There was an antecedent in the aggregation theory of the 19th century, and collectivist aspirations through progressive legal thought and New Deal. There was this idea to have a legal transplant of the real entity theory in the 1910s and 1920s, but that didn't last a lasting mark on US corporate law. Rather, since the 1960s, law and economics movement with a distinctively individualistic strain has dominated mainstream scholarship in the US. I will exemplify these differences with the corporate purpose debate. So we have the interest of the enterprise concept and the shareholder value maximization doctrine in the US. Interest of the enterprise in Germany. The purpose of the corporation has always been independent of the individual welfare of the shareholders. So it is sometimes explicitly extended to the interest in preserving the company's existence, even against the financial interests of its shareholders. And this interest of the enterprise also encompasses interests of other stakeholders and even public welfare concerns. In the US, the starting point, I think, is the shareholder primacy doctrine. The corporation operates to uphold the interest of its shareholders within the scope of the nexus of contracts concept. The idea is that in a hypothetical bargaining situation, shareholders would only accept their position as residual claimants in exchange for an alignment of the corporation's purpose with their interests. And this principle is firmly established in Delaware case law, albeit the subject of some controversy. The question is, how can we define a shareholder interest in greater detail? And I think closer shaping shows the individualistic character. Typically, we have the equalization with the long-term maximization of shareholder wealth. And in light of modern portfolio theory and finance scholarship, we equalized, or most scholars equalize the long-term maximization of shareholder wealth with the long-term maximization of the share price. And by that, the share price development in capital markets became relevant. This last point is not a clear requirement of Delaware law. And at the moment, there are some discussions about this part. So what are the practical differences? The traditional answer is hardly any, because there is a business judgment rule and generally a broad managerial discretion and non-enforceability of stakeholder interests. But however, I think the distinction between standard of conduct and standard of review needs to be taken into account. When you have a different standard of conduct, even if the standard of review is a high burden, then you have real effects of this standard of conduct on decision making. And we saw that by, for example, the dismantling of conglomerates in the US that started in the 1980s. We have a different capital structure. We have the importance of share buybacks that is very different in the US in comparison to Germany. And we have a culmination in so-called endgame situations when relevant duties kick in. Now, a change of perspective, economic convergence. We saw in the last years, and we already observed that we have a increasing actual convergence of shareholder structures due to the concentration of share ownership among institutional investors, and also a breaking up of traditionally concentrated ownership structures in Germany. We can see a shift in investor preferences, so a focus on ESG considerations increases. And we have political support for this shift in investor preferences, even a political trigger of these preferences. Clearly in the EU, not so much in the US when you take the current political backlash into account. What are the consequences? Considerable increase in pressure on public corporations to take ESG concerns into account. Some speak of the rise of welfarist corporate governance as a consequence. And my question is, will we see also So will we see an adoption of corporate law, first of all? And question two, will we see a convergence of corporate law theory, so a leveling of the paradigms? And for the first question, my answer would be yes, we will see adoptions of corporate law and corporate doctrine, but probably no convergence in corporate law theory. Because when you assess the more recent developments of corporate law and theory in the US, they take place primarily on an individualistic basis. So we have an adjustment to the changing environment by means of an adjustment of shareholder preferences. I call this a bottom-up approach. And in this respect, I only want to highlight two important concepts: the portfolio primacy concept that you are all well aware of. So institutional investors are interested in a reduction of portfolio-wide systemic risk, and that's why they want to have an influence on companies to decrease this risk, even if it's to the detriment of the individual company. This is contested whether this is possible under Delaware law, a single firm focus versus portfolio approach. On the other side, we have the shareholder welfare maximization doctrine by Hart and Zingales. Market value unequals shareholder welfare if externalities are not internalized. Shareholders are also part of the general public, and so the preferences of shareholders is not shareholder value maximization, but rather shareholder welfare maximization. How to identify these actual shareholder preferences? Solution: increasing shareholder rights and participation. Delaware law, at least tendencies in this direction when we see the Corbyn decision. Germany, a totally different approach. A top-down approach. The adjustment takes place via the interest of the enterprise concept. So whereas the prevailing opinion to date was that management may, but is not obligated to take ESG considerations into account, we have more recent tendencies to see an obligation of the company to take these ESG issues into account. And the explanation for that is that at least after the implementation of the CSDDD, management duties will be so heavily impacted by ESG considerations that there will be a presumption in favor of the existence of an ESG management duty that even goes above this legal duties of the CSDDD and other regulations. When you have this top-down approach, so the lawmaker is the one who decides how this interest of the enterprise is formed, then this also delegitimizes shareholder democracy. So the shareholder is out of the picture, his changing preferences are out of the picture, and this may, in some instances, lead to a functional equivalence, at least with regard to ESG considerations, as long as shareholder preferences and regulation match. But there is, of course, obviously potential for conflict, because in spite of all points of intersection, when shareholder preferences and legislation diverge and develop at a different path, then there is a conflict between these two paradigms, and we won't see a convergence or a functional equivalence in these instances. A particular concern in that regard is the political backlash. Thank you very much.